You're driving through Northern Virginia. It's a regular Tuesday, you're running late, traffic is as heavy as always on the I-395 in Arlington, and then blue lights in your rearview mirror. Your heart races, you signal, pull over, slow down, and the officer walks up to your window and asks you what seems like a simple question.
Do you know why I pulled you over?
And you, being a normal person, being a polite person, being someone who doesn't want any trouble, you answer. Maybe you say you were going a little fast. Maybe you say you didn't see the light. Maybe you just say,
I don't know.
and start explaining where you were going and why you were in a hurry. And in that moment, you just made your first mistake. Not because you did something terrible, but because you just handed the officer exactly what he needed to build a case against you. Today we're going to talk about something very few people know, and that can make the difference between walking away from a traffic stop without consequences or ending up with a ticket, points on your license, or something much worse. We're going to cover how a traffic stop in Northern Virginia actually works, what rights you have, how to exercise them without escalating the situation, what you should say and what you should never say, and why the biggest mistake people make isn't bad driving. It's talking too much. Stay until the end because I'm going to give you an exact phrase, word for word, that you can use the next time you get pulled over. A phrase that is backed by law and that can protect you completely. I'm Pierre Priale, criminal defense attorney in Northern Virginia, and in over 15 years representing clients in courts like Fairfax, Arlington, Alexandria, and others, I've seen how a single conversation on the side of the road can destroy a case before it ever reaches the courtroom. Let's start by understanding something fundamental: why a traffic stop is not what it seems. Most people see a traffic stop as an uncomfortable but harmless moment. The officer pulls you over, gives you a ticket, or lets you go, and that's it. Done. But that's not what's actually happening. From the moment that officer turns on his lights and follows you, he's already collecting information. He's watching how you drive once you realize you're being followed. He's checking whether you change lanes abruptly, whether you speed up, whether you take too long to pull over. All of that is valuable information for them. When he gets to your window, the first thing he does is an evaluation. He's looking for warning signs, he's smelling the inside of the vehicle, he's looking at who's with you, what's on the seats, how you're reacting emotionally. And when he asks you that question,
Do you know why I pulled you over?
he's not asking because he's curious. He's asking because it's an investigative technique. It's an invitation for you to confirm the infraction yourself, to admit guilt in your own words, before he has to prove anything at all. If you answer,
Yes, I was going a little fast,
or
I think I didn't come to a complete stop.
you just saved the prosecutor a lot of work. He no longer needs witnesses, he no longer needs traffic cameras, he no longer needs to argue anything in court. You put the rope around your own neck. This is something attorneys see constantly. Clients who come in for a consultation saying, I told him yes, I thought if I was honest, they'd let me go. And the reality is that honesty, as understandable as it is, as completely human as it is exactly what was used against them. Before going further, I want to explain something called the likability bias and why your brain betrays you in these moments. The likability bias is the tendency we humans have to want to reduce social tension by being cooperative, explanatory, or simply being nice. When someone in a position of authority asks us a question, we feel a very strong internal pressure to answer. Not because we're guilty, but because from a young age we were taught that cooperating with authority is the right thing to do. That explaining your reasons makes you look like a reasonable person. That if you're transparent, the other person will be fair with you. And that works perfectly in many situations in life. With your boss, with your family, with your neighbors. But during a traffic stop in Virginia, that instinct, as natural as it is, as well-intentioned as it is, can cost you your license, your money, and your freedom. The problem is that the officer isn't there to be your friend. He's doing his job. And his job in that moment is to collect evidence. Everything you say is potentially information that can be used against you in Fairfax court, in Arlington court, or in Alexandria court. It's nothing personal. It doesn't mean all officers are bad. It's simply how the system works. And if you don't understand that, you're at a disadvantage from the very first second. What rights do you actually have during a traffic stop? This is where most people have a massive gap in their knowledge, because they know they have rights in general terms, but they don't know exactly what those rights are, when they apply, and how to exercise them without turning a traffic stop into a confrontation. Let's go through them clearly. The first is the right to remain silent. The Fifth Amendment of the United States Constitution protects you from self-incrimination. That means you are not required to answer questions that could incriminate you. You do have to identify yourself. Virginia law requires you to present your license, registration, and proof of insurance. But beyond that, you are not required to confess, to explain where you were going, to say how much you had to drink, or to answer any question that goes beyond your identification. The second is the right to know whether you are being detained or free to go. This is a fundamental right that very few people exercise. You have the right to ask the officer directly whether you are being detained or whether you are free to go. And that answer defines completely what your legal situation is in that moment. The third is the right to refuse consent to a search. If the officer asks you to allow him to search your vehicle, you have the right to say you do not consent. That doesn't mean they can't search it under certain circumstances, but it does mean that if they do so without your consent and without probable cause, that evidence can be suppressed in court. And the fourth is the right to an attorney. If you are arrested, you have the right to say nothing more until you speak with a lawyer. That right begins at the moment of arrest, not when you get to court. The problem isn't that these rights don't exist. The problem is that exercising them in the moment of the stop, in front of an officer with authority, in front of the lights, in front of the pressure, is something nobody prepares you for. That's why it's so important to have a phrase ready. A phrase that is respectful, that is legal, that won't escalate the situation, and that at the same time fully protects your rights. And here it is. Take note because this is the most important part of this video. If an officer pulls you over and starts asking you questions beyond requesting your documents, the phrase you should say is, "Officer, am I being detained or am I free to go? If I am being detained, I exercise my right to remain silent." That's it. No additional explanations, no apologies, no entering into conversation on the subject. Let's break down why this phrase works so well. First, because it's a direct question that forces the officer to legally define the situation. If there is no reasonable suspicion that you committed a crime, the officer cannot detain you. If he tells you you're free to go, you can go. If he tells you you're being detained, you now know exactly where you stand legally and you exercise your right to silence immediately. Second, because it is completely respectful. There's no confrontation, no attitude, no argument. You are simply asking a legal question that any citizen has the right to ask. That matters because you don't want to escalate the situation on the road. Your goal is not to win the argument out there. Your goal is to get to court with your case intact. Third, because it breaks the likability bias cycle. Instead of automatically responding to the officer's questions, which is what your brain does under pressure, you are taking control of the conversation with your own question. You shift the dynamic from "I answer, he evaluates" to "I ask, he defines." And fourth, because it protects your case. Everything you say during a traffic stop can be included in the officer's report and used against you in court. By exercising your right to silence from the beginning, you are removing from the prosecutor the easiest tools he has to build a case against you. What you should never do during a traffic stop. Now that you know what to say, let's talk about what you should never do. Because the mistakes that destroy cases aren't always dramatic ones. Sometimes they're small things that seem completely harmless in the moment. The first mistake is answering the question,
Do you know why I pulled you over?
"We already talked about this, but it's worth repeating." This question has no winning answer. If you say yes, you admit guilt. If you say no, the officer simply tells you why and moves forward with the same situation. The right answer is neither of the two. The right answer is to exercise your right to silence. The second mistake is volunteering explanations.
I was coming from work. I was in a hurry because my son. I don't normally drive like that, but.
Each one of those sentences is a voluntary statement that the officer can include in his report. They don't help you. They only give the system more information to work with. The third mistake is consenting to searches out of politeness. The officer asks,
Do you mind if I take a look at the vehicle?
and you say no problem because you have nothing to hide. That is a serious mistake. Not because you have something to hide, but because by giving your consent, you are waiving your legal protection against searches without probable cause. If something is found, no matter what, you can no longer argue it was an illegal search. The fourth mistake is arguing the law with the officer on the side of the road. If the officer says something you disagree with, if you feel you're being stopped unfairly, if you think your rights are being violated, the road is not the place for that debate. The place for that debate is the courtroom. Arguing on the road only escalates the situation, can result in additional charges for obstruction, and changes absolutely nothing in legal terms. The fifth mistake is making sudden movements or not communicating your movements. Before reaching for your documents in the glove compartment, tell the officer what you're about to do. My documents are in the glove compartment, I'm going to get them. That may seem unnecessary, but in a tense state, movements the officer doesn't anticipate can escalate the situation in ways nobody wants. And the sixth mistake is assuming that because you didn't do anything wrong, you don't need to protect yourself. This is perhaps the most common and most dangerous mistake of all. Many people think rights are for people who did something bad, that if you're innocent, you just cooperate and everything turns out fine. But the legal system doesn't work that way. Rights exist precisely to protect everyone, guilty or innocent, from a process that can be very imperfect. Not using them doesn't make you more honest. It only makes you more vulnerable. Let's talk about some concrete scenarios because theory matters, but what you really need is to know how to apply this in real life. Scenario 1. You get pulled over for speeding on I-66. The officer comes to your window and says,
Good evening. License, registration, and insurance, please.
You hand them over without saying anything else. The officer reviews them and asks,
Do you know how fast you were going?
You respond, Officer, am I being detained or am I free to go? If I am being detained, I exercise my right to remain silent. The officer may insist, may ask more questions, may seem irritated. You repeat the same phrase calmly and respectfully without adding anything. In the worst case, he gives you the ticket. In the best case, he doesn't have enough to give you the ticket. And in either case, you didn't give him additional information for the prosecutor to work with in court. Scenario 2, you get stopped at a sobriety checkpoint in Fairfax. The officer asks,
Have you been drinking tonight?
This is a question specifically designed to get you to incriminate yourself. The answer almost everyone gives,
I only had 2 beers.
is a partial admission the officer can use to justify additional testing. The correct answer is to exercise your right to silence. Officer, I exercise my right to remain silent. Hand over your documents if asked. Add nothing more. Scenario 3. The officer asks you to step out of the vehicle. This is important. In Virginia, if an officer orders you out of the vehicle for safety reasons, you are legally required to comply. The Supreme Court has upheld this. But how you exit and what you do afterward is within your control. You step out of the vehicle, you close the door behind you immediately, and you say, Officer, I'm complying with your order to exit the vehicle, but I do not consent to any search of my person or my car. Am I being detained or am I free to go? And the detail of closing the door is critical. If you leave the door open, you are giving the officer a visual invitation to see inside the vehicle. What is in plain sight can be used as justification for a full search. Close the door. Always. Scenario 4. The officer says he has reason to suspect something and wants to search the vehicle. Here's something most people don't know. The officer can search your vehicle if he has probable cause. But probable cause has to be real, has to be specific, and has to be justifiable before a judge. If the officer tells you he's going to search the vehicle, you clearly state, I do not consent to this search. You don't physically stop him, you don't obstruct the search, that would be obstruction. But you make a clear verbal statement that you do not consent. If the search is conducted without your consent and without real probable cause, that evidence can be suppressed in court, which in many cases means the entire case falls apart. And the fifth scenario is, they ask you to perform field sobriety tests. In Virginia, field sobriety tests, walking a straight line, following a finger with your eyes, standing on one foot, or even blowing, are voluntary. You are not legally required to perform them. And this is something officers don't always communicate clearly. These tests are designed to be difficult to pass even for completely sober people under the pressure and stress of a traffic stop. You can say, Officer, I do not consent to performing field sobriety tests. I exercise my right to remain silent. This doesn't mean there won't be consequences, there may be, but it is an informed decision that in many cases is the right one. Why all of this matters even more in Virginia and the DMV. There is a specific reason why everything we just talked about is especially important if you live or drive in Virginia, Maryland, or Washington, D.C. In the Commonwealth of Virginia, there is something called pure contributory negligence. We've touched on this in other contexts before, but it also applies in traffic cases. Basically, if it can be proven that you contributed even minimally to the situation, that can be used against you. But beyond that, Virginia has some of the strictest traffic laws in the country. An infraction that in another state would simply be an administrative fine can be a criminal charge here. Speeding more than 20 miles per hour over the limit in Virginia is a Class 1 misdemeanor, which is the highest misdemeanor category, the same category as minor criminal offenses. And reckless driving can result in up to 12 months in jail and up to $2,500 in fines. That means what looks like a routine traffic stop in Virginia can very quickly turn into something with real criminal consequences. And if you already said too much on the side of the road, if you already explained to the officer why you were speeding, if you already admitted you didn't see the sign, the defense work your attorney has to do in court becomes enormously more complicated. In addition, the DMV area in particular has a highly diverse population and many people who are not American citizens. For these individuals, the consequences of a criminal charge go far beyond a fine or points on a license. A criminal charge can affect an immigration process, can affect a citizenship application, can affect a work visa. What for one person is an administrative inconvenience, for another can be a life-altering crisis. That's why at Right Path Law Group we have seen so many cases where the problem wasn't the original infraction. The problem was what was said in the first 5 minutes after those lights came on. What to do after the stop. Let's say it's already done. The officer already pulled you over, there was already a conversation, you already drove away. What do you do now? The first thing you should do, and you should do it as soon as possible, is write down everything you remember about that stop. The time, the exact location, what the officer said, what you answered, whether there were any witnesses, what the weather was like, whether there were any traffic cameras in the area, everything, because your memory will start to shift over time. Details that seem irrelevant today may be crucial to your defense tomorrow. The second thing is to not talk about the case with anyone except your attorney. Not with your family, not with your friends, and especially not on social media. Everything you say about the case can eventually make its way to the prosecutor. That may sound excessive, but it's advice attorneys give constantly, and that is constantly ignored. The third thing is to not pay the ticket without first consulting with an attorney. Especially in Virginia, where paying a ticket is the equivalent of pleading guilty. Depending on the charge, it may be very much worth contesting the ticket in court, especially if something during the stop wasn't done correctly, especially if your rights were violated in any way. And the fourth thing is to contact an attorney as soon as possible, not because every traffic case is a life or death situation, but because the window of time to act is short, and the sooner an attorney has all the information about the case, the more options he will have to defend you. Before closing, I want to answer some of the questions we receive most often on this topic. The first question is, I exercised my rights and the officer gave me the ticket anyway. Does that mean I lost? No. Getting a ticket at the stop doesn't mean the case is closed. In Virginia, you have the right to contest a ticket in court. And in many cases, especially when you didn't give the officer additional information at the stop, there are legal arguments that can reduce the charge, change it to something less serious, or in some cases, eliminate it completely. The second question is, can I record the interaction with the officer? In Virginia, the law allows you to record interactions with police in public spaces. You have that right, but you have to be smart about how you do it. Recording openly without concealing it is the safest approach. And if the officer asks you to stop recording, it's important to know that in most cases, legally, you don't have to, although that may escalate the situation. This is a topic where it's worth consulting with an attorney about the specific circumstances. The third question is, what if the officer tells me that if I don't answer his questions, he's going to arrest me? That is a pressure tactic. The act of exercising your right to silence is not in itself a legal reason to arrest you. If the officer arrests you solely because you didn't answer his questions, that may be a violation of your rights that a good attorney can use in your defense. And the fourth question is, what if I don't speak English well? You have the right to communicate in your language. You have the right to request an interpreter. And if a statement you made was misinterpreted or misunderstood by the officer, that can also be relevant to your defense. We've reached the end, and I want to close with this. Exercising your rights during a traffic stop doesn't make you a suspicious person. It doesn't make you a difficult person. And it doesn't make you someone with something to hide. It makes you someone who understands how the system works. It makes you someone who protects themselves the way the law allows you to. And in the DMV, where the laws are stricter than in almost any other part of the country, and where the consequences of a criminal charge go far beyond a fine, that knowledge has enormous value. Remember the phrase, "Officer, am I being detained or am I free to go?" If I am being detained, I exercise my right to remain silent. Practice it. Tell it to your family, tell it to your kids who are learning to drive. Because the moment you're going to need it is not the moment when you have time to look it up in a video. And if you've already been through a traffic stop, if you already said more than you should have, if there's already a case pending against you in the courts of Fairfax, Arlington, Alexandria, or anywhere in Northern Virginia, don't wait. Time works against any legal defense. At Right Path Law Group, we have been handling exactly these cases for over 15 years. We know how the DMV courts work, we know what arguments hold up, we know how to build a defense from day one.